May it please the Court, I'm Richard E. Brodsky. I represent the appellant, Fulgencio Zaldivar. With me, behind me, are the lawyers who handled the case in the original proceedings, Margaret Brodsky and Armando Karla. May I ask for a warning after 6 minutes? Is that possible?
Sure.
Thank you. And I'd like to reserve a minute and a half. May it please the Court, this is an appeal from the denial of a 57-105 motion arising from 4 dependency petitions brought under Chapter 39 against Dr. Zaldivar. Of course, each case presents conflicts of legal principles for the application thereof. Here there are 2 principles involved which are elevated interests. One is you don't file or maintain pleadings that you knew or should have known, were lacking in either evidentiary or legal support. That's enshrined, of course, in 57-105. And the second is a constitutional principle that the government cannot unreasonably interfere with the constitutionally protected rights of parents.
Well, you didn't bring an action in 1987 or 1983, a violation of constitutional rights. You basically will prevail or not prevail on the basis of the statute.
You're absolutely right, Your Honor. I'm simply talking for context of what is.
You've got to establish first that you're the prevailing party, and then we also that there was no justiciable issue of fact or law. The court, after hearing extensive testimony, made a finding that you were not the prevailing party because your client had interjected the issue of custody into the dependency proceeding, and basically he did not prevail on that issue.
I don't believe that's an accurate recitation of what happened below.
No, I'm saying that that's what the court did.
I don't agree with respect with that interpretation of what the court did.
Okay.
What the court did, and the fundamental error in this case, is the court mixed 2 or 3 different cases into one. There was an ongoing custody battle that had started when my client filed a motion for custody and to establish paternity.
Did you not, at one point or at any point in the dependency proceeding, file anything regarding custody in the dependency case?
No. Not that I'm aware of, Your Honor, and I believe I know the record well enough to say so. The problem is that in the context of the unified court, the trial court, having heard 3 different proceedings, custody fights, dependency as to the mother, and dependency as to the father, mixed all 3 and expressly on the face of her decision on 57-105, relied on and adverted to and focused on, almost to the exclusion of anything else, issues related to custody. Those were not raised in the dependency petitions as to Dr. Zaldivar. The only proceedings that occurred in connection with that were motions to dismiss and voluntary dismissals. The trial court mixed into her consideration expressly issues related to custody. In fact, she gave virtually no consideration to anything other than the custody proceeding or the custody aspects of the underlying custody case and the dependency petition as to the mother. The quintessential example of that, of her doing that, of the trial court's doing that, was on the prevailing party issue. The trial court ruled that because Dr. Zaldivar lost custody fights until at the end he was awarded custody, that meant that he was not the prevailing party. We did not raise on our 57-105 motions baseless, unsupported allegations by DCF in anything other than dependency petitions against the father. The trial court expressly stated that she refused to handle the issue of prevailing party solely on the basis of the dependency petitions as to the father. DCF, while supporting the proposition as they must that they were the prevailing party, doesn't support the court's view of how to get there. Rather, DCF says DCF was the prevailing party because we won the 57-105 hearing. And of course, under that theory, one could never, Your Honors, could never reverse a 57-105, an adverse 57-105.
In case number 06-15222, which is the dependency petition, you filed, or the father filed a father's renewed motion for custody using both the dependency case number and the family case number.
Can I ask for a page reference, Your Honor?
Oh, yes. 166 is the record reference.
That was, and would you mind, I'm sorry, didn't mean the page.
166?
Thank you.
It just seems very difficult to look at the dependency case without looking at the custody, because that usually is pretty much inextricably intertwined with all the issues in the dependency case.
Well, with due respect, Your Honor, it's not, and I want to tell you why. The dependency statute says that a child can be determined to be dependent.
By the way, the 6 minutes, you wanted one. I was fine.
Oh, the warning of 6 minutes is up? The dependency statute is a separate statute from custody. It's a separate statute from the Baker Act, and it's a separate statute from the statute that had DCF wanted to proceed, should have, throughout, and that is Section 39.5213B. What you have here is the use of the dependency statute to effect a goal, and that is to deprive the father of custody. The prime example of that is the fourth petition. Not only did the lawyer who filed that petition state under oath that she didn't know whether the allegations were true or false, that she didn't file it under any of the specific requirements of 39.01(15) or 14, depending on which year's statute we're talking about. But also, as she said, she voluntarily dismissed that petition after the court summarily and without a hearing denied the appellant's motion for renewed custody without hearing evidence, because, in the words of the DCF trial lawyer under oath in front of the trial court, I didn't need it anymore. Now, if Your Honors decide that in the family context, a dependency case can be brought sort of within the penumbra of underlying custody issues, then you will have eviscerated the lines between these carefully constructed statutory remedies. That is what it is at issue here, and I close with the simple proposition that the court, having considered the custody issues way outside of the 39.01, the dependency, violated the O'Grady case that this court has said requires reversal of a 57-105 denial if the court took into consideration issues not made part of the statute. I reserve whatever time I had left, which is probably not a lot. Thank you, Your Honor.
Thank you.
May it please the Court, Karla Perkins on behalf of the Department. The instant case is a case where we had a child who was clearly dependent. We had a case that originated back in Collier County in 2003. The case actually ended up in Dade County, but in 2005, when the case was still ongoing in Collier County, the appellant went into the family court division and filed in the 11th Circuit here in Miami-Dade and filed a petition for paternity. In that very petition, which was sworn, the appellant stated that the parental rights to the mother had been terminated involuntarily by the state in an early proceeding. Not true. And in that very petition to establish paternity...
I think we're getting a little far afield. We're looking at the actions of DCF, and it seems to me that they proceeded in reckless disregard for the truth here. They didn't pay any attention to what happened in Collier County. If they got the file from Collier County, they didn't read it. Either way, it seems to me that this is a travesty by DCF to have not paid any attention to what happened in Collier County, to have not spoken to the attorney for DCF in Collier County, and to file these accusations in the form of a petition which had very little basis in fact, no basis in fact.
Your Honor, respectfully, the Department would disagree. If you look at the record is clear that from back in Collier County, okay, the appellant was deemed October of 2005 to be a non-offending parent. Nothing was ever litigated. In January of 2006 was when the child made the allegation of the sexual abuse by the father. Now, for the Department to disregard something a child alleges, and if you look through the record, you will see where the child repeated it.
The problem is not that. The problem is that the Department apparently could not use the testimony of the child. They knew they couldn't use the testimony of the child because they had been ruled upon. They never talked to the child. It's just very... These lawyers that were filing these petitions did almost no investigation. And the trial court seemed to have gone off on the custody tangent. It seems that custody would be, the time spent litigating custody should be something that should be subtracted from the attorney's fees claimed, but should not be the basis for denying the attorney's fees in the first place.
Your Honor, you have to look. The Department has a mandated duty to protect children. In this case, we have the child not only stating about the sexual abuse, but she spoke to a psychologist, Dr. Lynette Levy, who may not have believed it first, but she also repeated to Dr. Wonderman, another psychologist, who did the review for her in terms of the child going into the psychiatric placement, but also back in May of 2006, even before the defendant's petition. If you look at the track, okay, if you look at the shelter petition filed, you will see clearly where the only thing that the Department had put in that petition was the fact that the father was not financially supporting the child, which was correct. He had established so-called paternity, which he later disavowed to get the first petition dismissed. But he actually was not paying the child any support. From July 2005, the court in Miami-Dade County entered the paternity order. In Collier County in February, an order was entered non pro tonque back to December of 2005, where that court actually heard about the mother being married, did nothing about it. The appellant's attorney said, well, no one appealed that paternity order, so he was the father. But we come back to 2006. This is July now, before the Department files the petition, right? If you look in the record, there is an evaluation by a psychiatrist, Dr. Bregman. In that report, he reports the sexual abuse of the child. So the Department was not going based on its own thought or just nothing at all. The department was relying, as the case of Department versus SE basically says, we can rely on medical opinions, medical experts. The child went from expert to expert telling the story. Dr. Chekowitz did an evaluation of this father. And in that evaluation, he put him at a low risk, not zero risk. And he found that the father was manipulating the whole process, evaluation process. So he could not even give a clear picture of the father. I mean, the documents all spoke of concern. If you look at Dr. Wunderman's, and I filed that with the motion to supplement, in her report, she clearly stated, you can't put this child with his father. This child is saying he's a bad man. They don't know whether the child's being manipulative, but Dr. Chekowitz found the father to be manipulative. So the problem is you have this child with severe mental problems. The child tried to commit suicide. If you look at the record, it tells you that back in May of 2006, she was Baker acted because she tried to commit suicide. She put a cord around her throat, tried to choke herself. She was Baker acted. She was then later on, down the road, interviewed by a number of medical experts. And they're the ones that kept saying, this child is saying something. You can't put the child back to the father. The child is desperately afraid of him. Nobody knows what's going on. And frankly, in terms of the department being able to prove the case, the department could rely on the child. So if the child came out of SIP and the child maintained that I'm not going back with his father, he sexually abused me, the department would then have to turn around and go to trial on the case if he kept denying it. Because the child has the right to be heard. If we were to disregard every single child who is telling us of whether physical or sexual abuse, and we're just going to dismiss, the department's attorney in Collier County did not do the right thing. The department in Miami-Dade County did the right thing. Because we have a child who definitely was going down and down and down to the point where what happened to her? She had to be placed in a psychiatric facility for 10 months. Not 1 month, not 1 week, not even 1 day, but for 10 months. That's to show you how severe the child was. And during that time period, the father kept fighting the department for custody of the child because he wanted the child out of that placement. That's not looking out for himself. That's not the best interest of the child. And you have a child who is maintaining he's a bad person. She's done bad things to her. For the department to say, well, we'll just ignore you and, because, the appellant says whatever. Well, the appellant filed all kinds of documents that are not correct. If anyone is not true in this whole scenario, it's not the department. Because the department went out of its way to protect this child. It's from pleading to pleading. First, he's telling the court that the mother has no parental rights to the child, so he wants it. He also stood up here and said something that's not true, because and I'm looking at page 85 of the record. This is an order signed by the judge, and it says it's addressed a number of things. The evaluation, possible coaching by any parent to be also addressed.
What's the date of that, please?
July 18, 2006. At the same time, the department filed the first shelter petition. The court went ahead and the court entered this order. It says feasibility reunification with mother or father to be addressed.
Okay, you're addressing the threshold, but how about taking us to 07 when we do the stutter step, the on again, off again amended petition after earlier dismissals?
The very first petition, which was filed on July 18th of 2006, was dismissed because of appellant not identifying to the court that there was a legal father.
I understand. I'm asking you about the petition for dependency March 30th of 07 and a voluntary dismissal 2 months later, after everything that had preceded it.
What happened there was the appellant kept insisting that he was not an offending parent. Okay. The court, at this point in time, the child was still in SIP. So there was no way for the child to testify at that very point in time. So what the court ordered appellant's attorney to meet with the department's lawyer. And this is where I also placed in the brief the issue of, you're telling someone to go ahead and do something and then you go and you complain that this was wrong. He told the department's lawyer because she discussed this with him at a meeting. And it's both in the trial testimony and it's in, I think, the May 18th transcript also, where she clarifies to the court, look, Judge, you ordered us to meet. We met. I told him, look, he lives in Panama. The child is in state custody, in a psychiatric placement, at the cost to the state of Florida. Okay? And she is going to draft a petition that says that she can't care for the child. That is absolutely true. She could not care for the child. The child was in the SIP placement. And the fact is he kept trying. He came up to this court trying to get the child back into his custody. And the transcript also of, I think, May 18th reflects where he tells the court, okay, if you don't want to give the child to me, take the child and give the child to the mother. But I don't want the child being treated any longer. And the child, who had an attorney ad litem, told the court the medication is helping her. You know, was he doing what was in the best interest of the child? Absolutely not. Was he doing anything to protect the child? Absolutely not. The only party that protected this child throughout the entire proceeding was the department. And the court...
Right, let me ask you a question. This is a UFC case.
Correct.
There's only a limited number of cases that are UFC. They're earmarked specifically, I believe, for Judge Karla exclusively. Is that correct?
Correct.
And is there anything in the record that indicates why this particular case or series of cases is in the UFC versus the general division?
What happened was, because appellants went and filed a paternity action over in the family division back in 2005, and then went back somehow to Judge Krieger or some judge there and got it, because of that paternity action, it was transferred along with the dependency action over into Unified Family Court, which is the two.
Okay, I see. All right. And could you address all the cases that opposing counsel has cited standing for the proposition that 57105 applies to DCF?
Your Honor, 57105 absolutely does not apply to DCF. And I'll tell you,
This would be the first case in the history of the state of Florida where DCF was hit with 57105?
Department versus SE was a case that was ruled on recently. And in that case where they sought fees, the district court, the fourth district said the department had every right to rely on medical expert opinion. That's exactly what the department has done here. And in terms of the 57105, and actually in the department's brief, we also have a federal case, White versus Ward. We have Black versus Mental Health out of California. And those all state that government officials are entitled to rely on the opinions of medical professionals. In terms of the requirement under 57105, okay, one, none of the petitions could the appellant really have been found to be the prevailing party. Collateral estoppel, which he used to try and knock out petitions 2 and 3, okay, there was no litigation ever done on those issues. The department was not estopped, and frankly, the problem was the department went ahead and dismissed counts that should not have been dismissed. I mean, he never proved that he was paying financial support. Instead, his pleading says he stands ready at all times to pay the support, but it's the mother, who is a horrible mother, why he can't even pay the child support.
Now, you've gone over your 10 minutes. Could you wrap up your argument?
Thank you. Your Honor, the trial court below correctly found that there was no justiciable issue in this case. The department, in its mandated role as protector of the child, did exactly what it is required to do. And we ask that you affirm the lower court. Thank you.
Do I have any additional time?
Yeah, we'll give you a little extra because she took a little extra.
First, 57105 definitely applies to the state of Florida and to an agency thereof. It has never been suggested by the department that it doesn't, and there's no...
I'm asking you, what cases are you relying on specifically where the department was required to pay fees under 57105?
I'm not aware of any specific case.
This would be the first case in the history of the state of Florida.
This might be the first reported case. I'm not aware of cases that are unreported.
Rest assured, if the department was forced to pay attorney's fees, they would have appealed it.
I can assume that, Your Honor.
I would assume that.
I think that's a fair inference.
Okay.
And of course, there's always a first time.
No question about it. I just let me say the issue tickles my fancy.
Yes, Your Honor.
Why shouldn't sovereign immunity apply? I mean, they've waived, the state has waived sovereign immunity in the tort. This is not a tort, for which you given notice under 76828.
The case law, this is not a tort case. This is a statutory remedy that applies to the state. The cases that I cited in my brief.
The state is not mentioned in 57105.
But the cases state that the state agency is a party and therefore is bound just as a private party is by 57105.
By implication, you're saying that 57105 waives sovereign immunity?
If you're on, I'm sorry, I was interrupted. May I ask you to repeat your question? I apologize.
You're saying that 57105 by implication waives the state's sovereign immunity?
I'm not prepared to say that, and the reason is that I don't think that the doctrine of sovereign immunity applies to begin with.
Why wouldn't 57105 then apply to the state in the prosecution of a criminal case? They could say they're a party because they're the plaintiff, and if they wrongfully accuse somebody, they could be subject to fees.
I have to say that I'm going to rely on the cases that have uniformly held without any variation that 57105 applies to the state. The issue of sovereign immunity has not been raised before, and I do not hold myself out to be an expert on the subject, but my understanding is, subject to the right, if Your Honor please, to file a supplemental brief on the subject if Your Honor considers it important enough for us to comment on. My understanding is the doctrine applies to tort claims primarily, if not exclusively. But I must say that, in all humility, I wasn't prepared to answer that question other than what I've told you. And may I ask if the Court would permit us to file a supplemental brief on this subject? If the Court wishes, we would be happy to do that.
We will let you know if we need supplemental brief.
I appreciate that. Very briefly, counsel has dodged and avoided the issues. First of all, the best interest standard doesn't apply to this proceeding. It comes from a different statute and has nothing to do with the pendency case. She said dramatically, the department can't ignore the accusations. The department didn't ignore the accusations. The department office that was in charge investigated the accusations with the CPT investigator and made a determination, in the words of the attorney who testified in court in the 57105, that the accusation was bizarre and incredible. And she decided not to bring the case. She wrote the order that the judge signed, and the issue of the accusation was expressly raised in that judge's court before he signed the order. So the idea that these people are on the white horse with the white knight and the white hat doesn't match reality. Finally, every single issue she's raised has to do with custody, which is eerily reminiscent of the procedures under the 57105 hearing and the decision of the trial court. Thank you for your time.